September, the Hawaii State Supreme Court is expected to rule on the legality of same-sex, same-gender marriages. Will same-gender couples be allowed to marry and be accorded the same benefits and legal rights that come with matrimony? Currently, gay and lesbian couples are not allowed to legally marry, but the Hawaii ruling may change that. When it comes to regulating marriage, what authority rests at municipal, state, and federal levels of government? How about the United States Constitution and same-gender marriages? How will the recent United States Supreme Court ruling on gay rights influence this issue? Importantly, what could the response be in Oregon? Some states in the United States have already passed laws that would invalidate same-gender marriages. Our speakers in today's forum are eminently well qualified to discuss these issues. Jon Terry, our first speaker, is a law partner at Terry and Wren. He is co-chair of the Oregon Gay and Lesbian Law Association and also co-chair of Oregon's Freedom to Marry Coalition. As a specialist in domestic relations, he can discuss legal issues surrounding marriages with confidence. His law degree comes from the Lewis and Clark Northwestern School of Law. Our second speaker will be Madelyn Wessel, who is the Chief Deputy City Attorney for Portland. She has expertise in constitutional, civil rights, and affirmative action law. She drafted the Portland Civil Rights Ordinance, and her civil rights and affirmative action activities have garnered her awards from the American Civil Liberties Union and the Women's Foundation of Oregon. Her law degree comes from Boston University. Both of our speakers are German translators. We await their comments in English on this fascinating subject. Mr. Terry will speak first.
I promise to only speak in English. Good afternoon. My name is Jon Terry, and as Fran told you, I am a partner at the law firm of Terry and Wren. On behalf of the Oregon Freedom to Marry Coalition and my partner, Kevin Canyo, whom the law doesn't allow me to marry, I appreciate the opportunity to address you today on this very important topic of same-gender marriage. In considering same-gender marriage, it is important to recognize the general pervasive discrimination that gays and lesbians face in society today. Not only can we not marry each other anywhere in this country, we can be fired from our jobs simply for being gay or lesbian. No federal law protects people on the basis of sexual orientation. However, around 80% of the American public today oppose job discrimination on the basis of sexual orientation. Nearly 1/3 of all Americans support same-gender marriage. However, 45% say that they've not made up their minds how they feel about same-gender marriage. For years, gays and lesbians have been criticized for their supposed type, the one that says that we don't attach to and make committed relationships. They don't want us to form a legally binding long-term and committed relationship. I firmly believe that most opposition to same-gender marriage is born of animus, anti-homosexual animus. In other words, people who dislike homosexuals are likely to oppose same-gender marriage. There are those who support gay and lesbian rights and still say that they do not support the freedom to marry. It is to those people that I would like to address my remarks today. To bar any class of people from marrying creates disenfranchisement. That is a fact we cannot get around. If we look back to 1967, in a case that Madelyn's going to tell you more about in Loving versus Virginia, there was pervasive disenfranchisement caused by the fact that same-race folks could not marry. That fact cannot be denied today. No one could say that the disenfranchisement that folks who were of multi-races had was not a very real fact that had to be dealt with. I want to tell you a little bit about the Hawaii case. It's now called Bear versus Miike, so when you hear Miike, it's the same thing. It used to be called Bear versus Lewin. In that case, three couples went to the folks at the state of Hawaii. It's actually the health department who issues those marriage licenses, and said, we want them. The health department said no. What did they do? They filed a lawsuit. They went to the courts and they said, hey, those folks won't give me a marriage license. And the court said, and they don't have to. Following naturally, they appealed that decision. And it went all the way up to the Supreme Court of Hawaii. And the Supreme Court of Hawaii said, we're sorry, but if you're going to deny these folks a marriage license, you're going to have to give a compelling state reason why that should be done. They remanded the case back to the lower court, and it's now awaiting a decision. In the meantime, the governor of Hawaii commissioned a report. And in that report, he said, come up with a compelling state reason to deny same-gendered folks the right to marry. I want to show you the report. Here it is. It's a big report. And the conclusion from the report is that not only can we not come up with a compelling reason, we can't even come up with a rational basis decision or reason to deny same-gendered folks the right to marry. That's where we are right now. We have this report. There's a minority report, and they cite procreation, an issue I'll talk about in a minute, for why we ought to deny same-gendered folks the right to marry. There's some national implications that have caused us to come here today to have this debate in Oregon. Because if folks can get married in Hawaii, the question becomes, should that be recognized in all states? And that's some more issues that Madelyn will address in a little bit. Many same-sex couples share the same responsibilities and commitments that married couples do. However, nowhere in the United States do they receive the same recognition and benefits as married couples. In fact, they face massive discrimination. Now, I asked myself, what is marriage? Because that's the root of the debate here today. What are we talking about? Let's get a definition of marriage on the table so that we all come to a level playing field. Well, this is my definition of marriage, which I've adapted from over 2,000 pages of material which I've digested to come to you today. Marriage is an institution that defines how we think about one another, formalizing contacts with our families. Tautologically, state-sanctioned marriage is the only way a couple is bound together in the eyes of the law. In short, it defines families. Marriage is, and it always has been, an institution that changes with times. We only need to think about the Loving versus Virginia case to bring that point home. It is not just to procreate, as many people would have you to believe. There are lots of other reasons. I want to say procreation is but one function of marriage, and many gays and lesbians have children. In 1991, the Harvard Law Review editors did a study, and in that study, they came back and reported that 3 million gays and lesbians have children today, and that between 8 and 10 million people, 10 million children, are being raised by gays and lesbians. That's no small amount of people that are being disenfranchised because gays and lesbians are prohibited from being married today. So who can marry? Let's talk about that for a minute. Well, I want to tell you the state's not choosy about it. As I've heard it said, it's harder to get a driver's license than a marriage license. There are very few prerequisites. The Oregon statutes say you have to be unmarried, you need to be 17 years of age, you can't be first cousins or closer, but that's about it. If you can get a marriage license, it says more about your ability to fill out a form than about your ability to enter into a healthy relationship. And that's the truth. If you can go down to the city hall and get the form filled out, and you're 17 years of age or older, you're not marrying your cousin, you're going to get your marriage license. This is a civil contract. And in a minute, I'm going to talk about why religion doesn't have a place here. All I'm talking about right now is what you have to do to satisfy the civil requirements of marriage. Now, the next question that I asked myself is, what's the purpose of marriage? Because if we get beyond the definition of marriage and we say marriage is has a unitive purpose, it brings couples together, all right, then we have to continue to ask ourselves, what does it do for us as a society? Why do gays and lesbians want to get married today? What's really going on? What's the underpinnings of this debate? Well, I would argue that marriage stabilizes individuals, and it encourages civic virtues. It allows children to be raised with confidence in their parents and their place in the world. Those 9 to 10 million children, they deserve the self-esteem that comes with having their parents' relationship recognized by the state. I would argue further that the purpose of marriage is that it builds interdependence among family members. Parents send their children to school. Spouses aid ailing spouses. As the AIDS epidemic has shown us, gays and lesbians rally when somebody is sick. We can enter into this unitive function just as well as anyone can. Further, another purpose of marriage is that we share resources with each other. We help each other to become more productive citizens. Marriage builds these virtues through a variety of rights. Now, I want to talk to you about the rights that are granted a married couple that gays and lesbians do not have and cannot get. Through some of the most careful planning, some of these rights gays and lesbians cannot have today. The first ones I'm going to mention are rights that you can have if you're careful. If you go hire a lawyer and you do some very, very careful planning, you can get these rights. The right to make burial decisions, that's one right. You get automatically if you enter into the civil contract of marriage. The right to automatically inherit without a will. You do not have that as a gay or lesbian couple. You must form a will, and you must do it very, very carefully. And if you make a mistake, then your family can attack that will. If you're married, it's not going to happen. The right to seek wrongful death benefits if a spouse is killed. This is a very, very important benefit. We cannot get that. Under every code of law that I have been able to find, at no time in our history has a domestic partner been able to bring a wrongful death action when their partner is killed in a plane crash, in a car wreck, anywhere. It's not happened. Some other rights that I think are interesting. The right to crime victims assistance recovery benefits. Spouses are automatically entitled to that. The right to file joint tax returns. The right to legal protection if the marriage dissolves. Now, I've heard a lot of people say, we don't want the right to get a divorce. But quite frankly, it's a right that we need. It's a right when relationships break up. They deserve to be orderly. And we don't have that order right now in our relationships, and that causes disenfranchisement. Another very important right is a privacy right. What you tell your most intimate partner, your spouse, ought to be kept private. You ought never to have to divulge that. Under Oregon law, if you're married, husbands and wives can never be forced to say what their partners told them in private. Gays and lesbians would have to do that. First and foremost, marriage symbolizes interpersonal commitment. It can be, but is not always, an expression of one's religion and morals. I want to talk about that issue now, the issue of religion, because I think it's important to make this point. It shouldn't play in this debate. We are talking about civil marriage, not whether or not a church should recognize marriage, not whether or not you as a person of conscience in your religion think that marriage is right or wrong. We're talking about the civil commitment to marriage. Separation of church and state is alive and well, and it ought to be. To say that gay marriage is anti-Christian and anti-God is inaccurate at best. Prior to 1300, both the Roman Catholic Church and the Greek Orthodox Church performed same-gender unions, and there are some very beautiful liturgies which I have read that are still in existence today from when the Catholic Church and the Greek Orthodox Church performed these same-gender unions. Both the Reform and the Reconstruction branches of Judaism have now formally endorsed same-gender marriage. The United Church of Christ and the Unitarian Universalist Church, some Quakers and Buddhists, several Episcopal bishops and religious leaders have been advocating for same-gender marriage. It's their view that denying gays and lesbians access to matrimony violates basic principles. That's why it ought not be a part of this debate. We're talking about civil marriage, not what you think is moral, not what you think is religious. The fact of the matter is that we live in a country where that has to remain distinct. Not all religions agree.
To allow one faith to dictate state policy by adopting the concept of same-gender marriage is wrong, and it violates separation of church and state. Civil marriage is the way our society defines a person's most intimate and committed relationships. If you cannot marry your partner, the two of you will be ignored and slighted in ways both subtle and overt that would not be tolerated for a moment if you could marry. One of the main benefits of marriage is that it binds couples together, both in terms of the individual's perspective, but also in the public's perspective. Encouraging same-gender marriage is a vote of support for all families, however they're defined, which will encourage long-term, stable relationships, better and safer homes for children, and will achieve a step toward equality for everyone. As counsel for the plaintiffs in the Bear versus Liu in the Hawaii case said, you get your intellectuals, scholars, and activists in debate. It's a good debate, and it has to take place. But most people out there, their concerns are health care, better lives for their partners and children. They're not interested in politics, gay, straight, or any other kind. We must continue to debate this issue, and this debate will come down to a constitutional challenge. And here to speak with you about the constitutional challenge is Madelyn Wessel, Chief Deputy City Attorney for the City of Portland.
Thank you, John. Well, I'm about to launch into what at times may sound like a somewhat dry exercise in constitutional law, which may lead you to the belief that I'm actually speaking in German. Now, since it's so easy for lawyers to hide their feelings behind the verbiage, and some of you may be wondering, I thought it would be appropriate to go ahead and state my own personal views of the question of same-sex marriage right from the outset of my talk today. I personally support the rights of gays and lesbians to marry, and you're not getting a debate between me and John on that issue. My job, though, is to give you some understanding of the legal landscape, especially the constitutional landscape surrounding same-gender marriage. In that context, some of you may be wondering why an attorney for a municipality is speaking to you today, and that's a pretty good question. In the constitutional pecking order respecting marriage, the state is on top. The federal government comes next, although it sometimes gets to trump the state. And everyone, absolutely everyone, agrees that municipalities are at the bottom of the heap. Nevertheless, the fact that the state is preeminent in matters of marriage does not mean that municipalities are without the power to support the struggle for gay and lesbian rights. To the contrary, cities across the country have often been at the legal epicenter through their gradual enactment of civil rights ordinances of the battles and the struggles to protect gay and lesbian rights. In fact, the enactment of civil rights ordinances protecting gays and lesbians in some of Colorado's major cities led directly to the anti-gay amendment, which was at the heart of the Supreme Court's all-important decision in Romer, which I'll talk about in a few minutes. So what is the breakdown of authority between municipal, state, and federal authority, and how does that affect our discussion here today? Municipalities are creatures of the state, and they take their authority in general as a legislative grant or delegation from the state. Municipalities in Oregon, like the city of Portland, have pretty expansive powers to protect public health, safety, and well-being. Because of that authority, the city of Portland has the power, and several years ago, under the leadership of City Commissioner Mike Lindberg, exercised the power to prohibit discrimination against a category of citizens, gays, lesbians, and bisexuals, not yet protected, even today, under the state's civil rights laws. Obviously, in most cases, cities, like other employers, are also free to offer their own employees domestic partnership benefits, a strategy which conveys a few, but only a few, of the financial benefits and securities of marriage to both heterosexual and same-gender unmarried couples. A few cities, like San Francisco, have also established a domestic partner registry for same-sex couples who wish to officially signify their commitments to one another. I've even encountered a few cases from elsewhere in the country in which a municipal prohibition of discrimination on the basis of sexual orientation or marital status has led to a ruling that all employers within that city must provide domestic partnership benefits, but these are few and far between. And that is about as far as I've seen such arguments going, because the closer any municipality gets to touching on matters pertaining to marriage and the status of children, the faster it finds itself staring in the face of this big giant gorilla known as the state. It is a basic tenet of American law that marriage belongs to the states, that marriage is subject to state regulation largely without federal intervention, and that it is a social relationship subject to the state's police power. Interestingly, this concept is anchored in some of the very important civil rights, civil liberties cases at the heart of our country's constitutional tradition. Cases like Meyer versus Nebraska and Loving versus Virginia, about which I'll have a few more remarks in a minute, are also cases which embody the very deep concept that the state controls, in general, the status of marriage. An early discussion of the state's supremacy in regulating marriage is found in a case ironically originating out of Oregon. It landed in the Supreme Court in 1888. The name is Maynard versus Hill. It appears that a Mr. Maynard set out for Oregon from Ohio in 1850, leaving his wife of 22 years and children behind, but promising to return or to send for them within 2 years. In the meantime, he promised to send her the means of support. Unfortunately, Mr. Maynard thought better of his promise. He never sent for his wife and children. Indeed, he never sent them any financial support at all. Soon after arriving in Oregon, he settled 640 acres of land and managed several months later to convince the Legislative Assembly of the territory to grant him a legislative divorce. The matter later came before the U.S. Supreme Court over a property dispute between various heirs. And that court stated in no uncertain terms its disapproval of Maynard's, quote, loose morals and shameless conduct. In fact, that court stated, quote, if the facts stated had been brought to the attention of Congress, that body might and probably would have annulled the act. With DOMA so much in the news these days, I guess this points out that even long ago, Congress had a high political interest in the defense of marriage. The Maynard court stated that marriage, as creating one of the most important relations in life, and as having more to do with the morals and civilization of a people than any other institution, has always been subject to the control of the state legislature. That body prescribes the age at which parties may contract to marry, the procedure or form essential to constitute marriage, the duties and obligations it creates, its effect on property rights, present and prospective, and the acts which may constitute grounds for its dissolution. Because the state of domicile had the supreme interest in regulating matters of marriage pertaining to its citizens, the court allowed the territorial legislature to terminate a marriage which had originally been created in another state, Ohio. Now, although states are powerful, very powerful in defining the conditions and machinery of marriage, they are not without constraints. That is where the federal role comes in the form of our federal Constitution. But before we dive into the federal constitutional issues, we need to stop for a minute for a quick review of Con Law 101. In evaluating constitutional claims against government, the Supreme Court has traditionally established 3 different standards of review. The first is called rational basis review, and under this very modest standard, the court typically defers to a state's decisions if there is any conceivably legitimate basis for them. Strict scrutiny, the most heightened level of judicial review, was established over time as the court's standard for evaluating actions which discriminated against minorities or which infringed fundamental rights under the Constitution. Intermediate scrutiny is just that, neither strict nor rational. In a beautiful example of legalese run amok, it has been applied to what are sometimes termed quasi-suspect classes or quasi-fundamental rights. As an aside, I had a case a few years ago in Massachusetts, which involved both a quasi-fundamental right and a quasi-suspect class, and we used to hang out at night and wonder whether if you added 2 quasis together, you could get 1 strict scrutiny, but nobody was convinced. Anyway, intermediate scrutiny is most often used as the standard to apply to discrimination against women. This is, of course, to Justice Ruth Bader Ginsburg's enduring regret. So much of her early career was spent trying to convince an earlier Supreme Court, on behalf of women's civil rights interests, that gender discrimination ought to be subject to the same strict scrutiny review as race. Well, now, Con Law 101 aside, and returning to the issue of marriage, and this will have relevance in just a minute, It is precisely because of the ringing language in cases such as Maynard over 100 years ago that the United States Supreme Court over time began to acknowledge that choices surrounding the decision to marry and were central to any picture of fundamental human rights, and began to build a basis for believing that restrictions on marriage might be subject to that strict scrutiny that every civil rights lawyer craves. And so we have later cases such as Skinner versus Oklahoma. Skinner involved a man who faced involuntary sterilization under an Oklahoma statute which permitted this for persons who had committed 3 or more relatively petty property offenses. In Skinner's case, the first offense involved stealing chickens. I guess we should just view this as an old and early example of 3 strikes and you're out, but they sure meant it. Anyway, the Skinner court invalidated the Oklahoma law on the basis that the state's hegemony on matters relating to marriage and procreation had to bow at some point to the federal constitutional guarantees of equal protection of the laws. We are dealing, the court said, with legislation which involves one of the basic civil rights of man. Marriage and procreation are fundamental to the very existence and survival of the human race. Later, in Loving versus Virginia, the case John mentioned earlier, and the case which is the most discussed today in the current examination of same-gender marriage, the court, but only in 1967, invalidated Virginia's absolute ban on interracial marriage. It's worth noting that at the time of the Loving decision, 15 other states also had such bans on interracial marriage on the books. 14 additional states had only repealed their bans on interracial marriage within the 15 years prior to the Loving decision, including Oregon. Let's also not forget that Virginia's law, like Oregon's had been, was a criminal law. The Lovings were sentenced to 1 year in jail for the crime of their marriage, a sentence that was suspended by the trial court on the condition that the Lovings leave the state of Virginia and not return together for 25 years. The judge justified his decisions with the following words, quote, "Almighty God created the races white, black, yellow, Malay, and red, and he placed them on separate continents. And but for the interference with this arrangement, there would be no cause for such marriages. The fact that he separated the races shows that he did not intend for the races to mix." Chief Justice Earl Warren made short shrift of the Virginia law, stating, quote, "There is patently no legitimate overriding purpose independent of invidious racial discrimination which justifies this classification. There can be no doubt that restricting the freedom to marry solely because of racial classifications violates the central meaning of the Equal Protection Clause." But we need to stop and pause at the Chief Justice's justification in Loving because it is notable for its complete reliance on the racial classification at the heart of Virginia's terrible law. The Loving court did not rest its opinion on the grounds that because marriage is a fundamental human right, strict scrutiny must be applied to any intrusion on that right. The Supreme Court has stated since Loving the relatively unequivocal position that marriage is a fundamental human right protected by the Constitution. In Zablocki versus Red Hill, the court, for example, struck down a Wisconsin statute which restricted the rights of poor persons to marry. But again, the justices in Zablocki, led by Thurgood Marshall in that case, who wrote the majority opinion, had great difficulty in deciding exactly why the law violated the Equal Protection Clause and just which of those constitutional standards we talked about, strict, intermediate, or rational basis, ought to be utilized. The court also mentioned that not all regulations of the incidence of marriage need be subjected to what it called rigorous scrutiny. As is so often the case in all of these cases, it really matters quite profoundly how the central constitutional question is framed. If the question is the state's suppression or denial of a fundamental right, the U.S. Supreme Court tends to put on very keen lenses and scrutinize the state's denial rather carefully. But except in Hawaii, the courts have thus far refused to apply that rigorous scrutiny otherwise applicable to denial of marriage to same-gender marriage claims. Courts have typically ducked the question with a definitional approach. Marriage, they reason, is by definition in every statute a union of one man and one woman. Therefore, there cannot be any marriage between two men or two women. And the refusal to grant the same is merely the denial of something which doesn't exist in the first place. This neat piece of, as John put it, tautological reasoning may be unpersuasive to many, but so far it has generally worked, except in Hawaii. If, alternatively, the question is whether discrimination against gays and lesbians on the basis of group status is afforded the strict scrutiny standard of review so as to bring the case under the umbrella in Loving, the answer so far has been a resounding no. This, of course, is above all the result of the Supreme Court's regrettable decision in Bowers versus Hardwick in 1986, in which the court refused to invalidate a Georgia law criminalizing adult consensual sodomy. The reasoning has gone since then: if homosexual acts can be made the subject of criminal sanction, then laws which otherwise discriminate against gays and lesbians cannot possibly be subjected to other than rational basis review. Strict scrutiny can't possibly apply. As I think most of the country by now knows, that 5-4 decision was dependent on Justice Powell's concurring vote, a decision which he has eternally regretted. This leads us to the final but most important decision to talk briefly about today, the Supreme Court decision in Romer versus Evans. In May, the Supreme Court overturned Colorado's Amendment 2, an anti-gay measure similar to the OCA's recent unsuccessful measures in Oregon. Amendment 2 was aimed at invalidating the civil rights ordinances passed in many Colorado cities. These ordinances, like Portland's ordinance, prohibit discrimination on the basis of sexual orientation. The amendment also prohibited any unit of government in the state of Colorado from affirmatively protecting gays and lesbians. In the court's analysis, Amendment 2 puts gays and lesbians in a solitary class in respect to transactions and relations in both the private and governmental spheres. The amendment withdraws from homosexuals, but no others, specific legal protection from the injuries caused by discrimination. In analyzing whether Amendment 2 could pass constitutional muster, though, the court made plain its view that rational basis review was enough. Remember that under the conventional wisdom, rational basis review is highly deferential, as I told you earlier, and typically results in affirmation of the statute or the law. But Amendment 2, even under that basis of review, failed, in the court's words, even defied the conventional inquiry. The court said the amendment had the peculiar property of imposing a broad and undifferentiated disability on a single named group, a broad one and an exceptional one, which was invalid. The amendment was fatally flawed in that it identified persons by a single trait and denied them across-the-board protection. The court concluded by saying, in words that are quite wonderful, we must conclude that Amendment 2 classifies homosexuals not to further a proper legislative end, but to make them unequal to everyone else. This Colorado cannot do. A state cannot so deem a class of persons a stranger to its laws. So among the many big unanswered questions resulting from Romer is whether the Supreme Court, which finally invalidated Virginia's anti-marriage laws 30 years ago, would be ready and willing to take the same approach to marriage restrictions based on sexual orientation. Another way to frame the question is whether Romer is the Brown versus Board of Education of gay rights. If Brown is the central geist animating the court's later decision in Loving versus Virginia, which of course it is, will Romer be the spirit behind a future same-sex marriage case, hopefully not one that would be decided in 12 years or more, which is the interval between Brown and Loving? My best assessment of the answer to that question is yes, but that it too may unfold at a Supreme Court level at least with that due and deliberate speed we remember from the school desegregation cases. In the meantime, we will be left to ponder the fundamental challenges and opportunities described by John, which are posed very immediately by the Hawaii decision anticipated in Bear. Through the likely enactment of DOMA, we appear also to be in for the singular fun of again demonstrating why the U.S. Congress can't undo the U.S. Constitution. In this case, the full faith and credit clause of the Constitution, no matter how politically expedient that outcome might be. Finally, as the famous constitutional scholar and Supreme Court advocate Larry Tribe likes to say, He, or in this case she, who lives by the crystal ball may learn to eat glass, and I may be wrong. But since you have two lawyers up here today, I'm going to turn things over to Jon for just a final minute for his chance to read that crystal ball.
At this point, Madelyn and I are going to be doing some prognostication, which I prefer to do seated.
It's easier to eat glass if you're seated.
Much easier to eat glass. What I want to talk about for just a moment is what is DOMA and what did DOMA do, and is DOMA constitutional? DOMA took away, let me start over. DOMA, what it does is it gives states policy to hang their hat on, to say we have strong public policy not to recognize a marriage validly performed in Hawaii. Second, it says that even if you get married in Hawaii and you're validly married there, if that ever comes about, you will not be entitled to federal benefits such as Social Security, pension benefits, anything the federal government passes out to spouses of heterosexually married couples, you will not be able to get, even if you are validly married in Hawaii or any other state that validly recognizes it. This was a very politically expedient thing for the state, for the federal legislature to try to do. As you know, it's right now in the Senate, and I can't prognosticate what's going to happen in the Senate. I know that Ted Kennedy is rushing around trying to attach an Employment Non-Discrimination Act to it, and what's going to happen with that, I don't know. But I can tell you, and use the language that Justice Kennedy used in the Romer opinion to prognosticate that whatever happens with DOMA, even if Congress is so bold as to try to pass it, I don't think it's going to survive. I want to go back and quote something which Justice Kennedy quoted in the Romer decision, which I think is very poignant right now. He says, 1 century ago, the first Justice Harlan admonished this court that the Constitution neither knows nor tolerates classes among its citizens. That was the dissenting view in Plessy versus Ferguson. It's now the majority view, and it's an important view. What DOMA does is it clearly creates two classes of American citizens if it passes. One will be the heterosexually married couple. One will be the homosexually married couple. They do not have equal rights. It's two classes of citizens, the homosexually married couple being the second class. Another very important point from the Romer decision is when Justice Kennedy quotes Shelley versus Kramer, another Supreme Court case, when he said equal protection of the laws is not achieved through indiscriminate imposition of inequities. This is where the state of Hawaii failed to come up with a compelling reason or even a rational basis reason. There aren't any. So we're not going to be able to find any reason why gays and lesbians shouldn't be allowed to marry. Finally, and most importantly, in my opinion, is another quote from a Supreme Court case called the Department of Agriculture versus Moreno. Justice Kennedy says, quoting that opinion, if the constitutional conception of equal protection of the laws means anything, it must at the very least mean that a bare desire to harm a politically unpopular group cannot constitute a legitimate governmental interest. And I submit that the only reason to prohibit gays and lesbians, bisexuals, transgendered people from getting married in our society today is born of animus toward homosexuals. And the Supreme Court has clearly said that's not sufficient. Procreation is an invalid reason to hang your hat on. The court has unlinked procreation from marriage. They're no longer together. Zablocki clearly did that. I'd like to end by making this a little bit personal. I want to adopt with my partner Kevin, and we are steadfastly working in that direction. And the reason that I want to be able to get married is so that the child that we have in this world and that we grow, as Fran says, grows in a healthy, and accepted environment, I have no illusions that merely allowing gays and lesbians to get married is going to bring us full social acceptance, any more than it has for same race or different race marriages. I'll tell you that in 1994, a study came out which frightened me. As I was reading for this, I read that 35% of Americans polled, of 5,000 Americans, were still opposed to different race marriages. And 6 out of 8 of those people polled said they opposed a close family member marrying someone from a different race. I was floored, completely floored, that after 30 years, this is still where we are. I don't think that allowing gays and lesbians to marry is going to create social acceptance, but I do think it's going to make it safer for us, and it's going to move us forward. And that's the direction that I think we're going, and I think that's the correct constitutional analysis, both under Romer and under the Baer decision in Hawaii. So.
You're finished? Thank you. As Greg is asking his question, City Club members with 30-second questions should begin to collect behind the microphone. Greg?
Thank you, John and Madelyn, for a presentation that was both impassioned and scholarly. My question is directed to John. Madelyn referred to the movement to extend employee benefits to domestic partners, that is, individuals with whom an employee shares a household. If same-sex marriage becomes permitted, should domestic partnerships cease to be recognized? That is, to put it another way, should marriage be the exclusive legal institution by which recognizing the formal relationship between cohabiting adult couples?
No. and some analysis. In our society today, we have increasingly moved away from agrarian reasons for marriage. We no longer are interested solely in the function of procreation. We're no longer interested in telling someone how they should form long-lasting relationships. And I believe that forcing somebody into a marriage relationship in order to have benefits is not the correct way to go. I think that we need to support and encourage people to form long-lasting relationships. If they choose to do so in the context of domestic partnerships, I think they ought to be able to do that. However, I think that, as has been made very clear, if you don't get married, you don't get that bundle of rights that I talked about. I want to show you something that I forgot to do in my presentation because I think it's very powerful. And it's also an answer to this question. Leo Schumann did some research for the Oregon Freedom to Marry Coalition. And this is the result. I love holding things up. This is the result of his research. It is a compilation of Oregon statutes and the Oregon administrative rules which convey rights on the basis of being able to be married. There are 700 Oregon revised statutes that convey rights and responsibilities if you're married, and 350 Oregon administrative rules. Now, that you get when you say, I do. And I think that domestic partnership remains a viable choice for many people. And I think that the progress that we've made in recognizing that makes us a stronger society, and it helps us to recognize families, however they choose to be defined.
I'm Greg Jackson. I'm Greg Jackson, club member and chair of the program committee. We'd like to welcome all the guests today, gay, lesbian, and heterosexual. If you're not a City Club member, we invite you to join. My question is a subjective question, and I know attorneys don't like subjective questions, so bear with me. If any other group of people or community were denied the legal right to marry in this country, and you can fill in the blank with the group or community of your choice, do you think there would be more of a national outcry on this issue, and why or why not?
Well, we might start with the Loving decision. I think it's always shocking to people who aren't already familiar that it took until 1967 for the Supreme Court to invalidate the most blatant form of equal protection violation, the race-based discrimination in Virginia's law. It's also indicative of the sort of general status of people's perceptions that up past the Second World War, more than half the states had those kinds of statutes on the books. If that type of highly invidious, classically recognized kind of discrimination could live so close to our own time, then I think your question is a hard one to answer. But clearly, there is a peculiar form of animosity towards gays and lesbians and bisexuals. And the fact is there is a lot of discrimination suffered by people based on their sexual orientation. And I think the struggle for same-sex marriage is one that will, is informed by that reality, as John pointed out earlier.
And in follow-up to that, do I think there's going to be a rush to the courthouse to say that bigamists or polygamists or anyone else ought to marry? I want to address that head on, because I don't think that that is the question. And I'll tell you that in every denial of marriage rights, that argument has been raised. When Loving was argued, people were saying, if we allow people of different races to get married, the next thing you know, gays and lesbians are going to want to get married. They said that in the briefing in Loving. They said there's going to be polygamists, there's going to be bigamists. They're all going to rush to the courthouse to get married as soon as we pass Loving. It's just not the reality.
I'm Charlie Hinkle, a member of the club. I want to ask a question about the Defense of Marriage Act, because I think that's such an intriguing title. It occurs to me that marriage is not like a basket of apples. If I eat an apple, you can't eat it because I've eaten it, it's gone. But if I get married, I haven't used up the supply of marriage. You can still get married even though I have gotten married. The proponents of DOMA in Congress said they were trying to defend marriage against attack. And I wonder, and I address this to you, John, in particular, if there's anything in that Hawaii study that you mentioned or any other evidence to suggest that making same-sex marriage available would cause heterosexual marriages to disintegrate or have any effect on the rate of marriage or the availability of marriage to anybody else?
Excellent question, Charlie. In fact, what the report concluded was that allowing gays and lesbians to marry today would support marriage because it would encourage us to form more cohesive family units, and that with a lot of the questions that have come up in this context has been, well, wouldn't that cause there's no way to argue that allowing a gay or lesbian, bisexual, transgendered person to marry would cause you to get a divorce. And if it would, you need to look at your relationship. And I just don't think it's a reality. I think that allowing gays and lesbians to marry adds one more unit to a desperately desired, cohesive family unit.
Press, Dr. Edward Press, member of the City Club. You both have done an excellent job, got me pretty well convinced. I have a question. One of the problems which you sort of mentioned when you talked about divorce, what about the potential problems of alimony and child custody? Is that going to be significantly different for same-sex marriages than it would be from different sex marriages?
I think the central point is that it would be exactly the same. It's not something different which is sought, it is simply the availability of the same existing structures that govern marriage and the dissolution of marriage.
Exactly the same.
Yeah.
Thank you.
Let me do a follow-up to that, because one of the concerns that I have is I've heard people ask the question, don't gays and lesbians want special rights? And it's not the case. The fact of the matter is that when you get married, you get a bundle of rights. Those books I held up, that's the bundle of rights that you want, that currently gays and lesbians are denied access to. All we want is equal access to that bundle of rights.
Do you think that there's a more frequent change of partners amongst gays and lesbians than there would be amongst different sex marriages, or is that non-contributory?
Very good question. I'm glad you asked that. Many people have, as I have been doing my research for this topic, in fact have argued, and I think convincingly, that what has led to the transitory nature of some gay and lesbian relationships, although not all, because I can tell you that in this audience I know of couples that have been together for 25 and 30 years, but part of what has led to the transitory nature is the fact that we don't get married, that society doesn't encourage us to stay together, and that in fact allowing people to get married will create a societal view toward lasting relationship that gays and lesbians will buy into.
Thank you.
This gives me an opportunity to ask another question. Greg McPherson, member of City Club. This question is for Madelyn. It appears that same-sex marriage encounters greater resistance in some states than in others, what constitutional obstacles would be faced by a local option approach in which same-sex marriage would be allowed in, say, Hawaii and Oregon, but not allowed in, say, the Carolinas?
Well, the full faith and credit clause of the Constitution is, of course, the major issue there. On a practical level, it is hard to think one's way through the thicket of being married here in one state and moving somewhere else and not being married. In fact, it's certainly not a burden we would expect heterosexuals to bear. It was, though, part of the issue that surrounded the gradual legalization of interracial marriage prior to Loving. And there were a lot of struggles and a lot of issues that surrounded if people were married in states which permitted interracial marriage and moved, what was the status of their marriage? I think on a practical level, it is actually a very complex question what the full faith and credit clause will mean, because it gives still individual states a certain amount of discretion to determine whether it might be against their public policy to recognize a certain kind of marriage.
And to follow up on that, it happens now where that certain marriages that are recognized and solemnized in one state are not legal in another state. That's why certain people of certain consanguinity, which means second cousins or third cousins, can't get married in some states. And some states have actually passed laws that say if you can't validly get married in this state, if you're a citizen of our state, you can't get around our marriage law by going to another state and get married and come back and expect us to recognize it. But that doesn't address the question of whether or not if your marriage is validly solemnized in Hawaii, it ought to be recognized everywhere.
B.J. Seymour, City Club member. As I understand it, if a given state recognizes a common law marriage where there has been no solemnization whatsoever, people have just lived together long enough that everybody thinks they're married, what is the rationale for failing to recognize a marriage that has been solemnized in one state? How can we tell states, or how can the federal government tell states, you have to recognize common law marriages if they are recognized in the state where this couple came from, but you can't recognize legal marriages between gays and lesbians?
Well, you're getting into a pretty intricate question which involves conflicts of laws analysis, and my understanding, and I don't purport to be a big expert on this issue, is that there is still an option open to states which haven't bought into a particular version of the restatement second, which allows them to not recognize marriages if it would be against the public policy of that state to recognize such a marriage. So there isn't necessarily always a translatability even of the common law marriage from one state to another. But the peculiar infirmity that is going to be visited on us through DOMA is that a particular category of legalized marriages that have been legalized in at least one state would not be subject in the congressional intent to the benefits of the full faith and credit clause analysis. My take on that one is that Congress can't do that. Congress can't undo the Constitution, thank goodness.
And I think maybe another and perhaps simpler way to think about the common law marriage question is that common law is based upon past law. We don't have any past law recognizing same-gender marriage, so that the answer to it might be, and this is just my initial hit to it, is that if there is no common law that says that homosexual marriage is recognized, then there is no reason why a state would say that we have common law marriage, because there is no law to say that.
Robert Smith, member. I have a question regarding what's currently available to families headed by same-sex couples. In the court system, in social services, is there discrimination? Are there exceptions made, or are all services available?
Okay. Right now, it depends on where you live, and that's a big problem. If you live in Multnomah County, then there are certain rights if you work for the county or for the city that you get as being a domestic partner. If you live in Oregon and you have a domestic partnership agreement, there are certain rights and responsibilities that can be accorded based upon contract. If you form a will, then you can create those rights. If you have an advance directive, which says that this is the way I want my death to be taken care of, or I want to be handled if I'm incapacitated, then those documents are available. But clearly, you must do careful planning rather than allowing for the law to make certain assumptions for you, or to allow the law to have your spouse to make those decisions for you. So the answer to your question is that if you're allowed to marry, you get that bundle of rights that I spoke about. If you don't, you have to do careful planning, and sometimes in the face of careful planning, it's to no avail.
A related question, then, are there groups promoting same-sex marriage, and if so, who are they within Multnomah County?
Well, the Oregon Freedom to Marry Coalition is composed of a number of groups of people. There are faith communities that are supporting the freedom to marry. There are political groups that are supporting the freedom to marry. And we have a resolution that Land Legal Defense and Education Fund has drafted. And there are literally thousands of organizations that have signed that resolution, which formally says that they take the position of promoting same-gender marriage.
Well, my terrifying moments of being a physician sitting on a podium with 3 lawyers is about to come to an end. And I thank Jon Terry and Madelyn Wessel for extraordinarily clear language and a beautiful job of making a complex and important issue understandable to all of us. Thank you very much.
I want to make one more comment, if I could, please. I'd like to make one more comment, and that was what we've done today is a thumbnail sketch of the issue involving same-gender marriage. Tomorrow, we're going to have a one-day summit in an 8-hour time where we're going to take a comprehensive look at same-gender marriage. Registration is at 8:30 at the First Unitarian Church. That's at 1011 Southwest 12th. If you have an interest in learning more about it, please come join us.
No.